So I'm a senior attorney at Grossman, Young and Hammond, and I will introduce myself briefly and then pass it over to my co-panelist, Thomas Harper. So my work at GYH focuses on all aspects of immigration law with a focus on humanitarian protections such as asylum. I also help individuals fight persecutory Interpol red notices as part of our firm's international protection practice. And before joining GYH, I spent many years as a federal litigator focused on immigration-related impact litigation. So Thomas, do you want to introduce yourself and then get us started?
Yeah, thanks. You are a very tough act to follow, I will say that. So I'm Thomas. I'm senior counsel for International Humanitarian Law here at the American Red Cross. In that capacity, I lead our International Humanitarian Law dissemination program. So all the text there, that's all great and good background. The really main thing to know about me, two things. Most of my adult life, if not all of it, has been spent in uniform in one capacity or another. So I have that sort of service-based perspective on things, to include practicing in this area of law during a deployment to Afghanistan during Operation Enduring Freedom. I've practiced in a variety of jobs as the Army JAG Corps is liable to put you through in their model for practitioners. But suffice it to say, this right here is a dream job for me, and I've been in this role for about 4 years now. The other thing to know, I'm a big Star Wars fan, so if I gratuitously layer in any Star Wars references, please apologize. Submit complaints to the Red Cross. I'll shield GYH from that liability at least. Thanks,
Thanks,
Gianna.
Thomas. Yeah, so this is our agenda. We're going to briefly cover the history of both international humanitarian law and how it intersects with immigration law and international refugee law. We're going to speak a little bit about enforcement and then also cover how a country can dial back or expand its commitments under either area of law, and discuss a little bit about what we anticipate in the coming administration. And then we'll have time for questions at the end.
All right. So I'll take it and be the history nerd for this first portion of things. And it's appropriate before we get into any of the where IHL came from to just understand at a 50,000-foot view what this body of law is. You'd be very surprised at the number of practitioners, at the number of senior military officers, et cetera, that regularly intersect with this body of law and don't have a full comprehension of what it is. And that's okay. That's why we have these things and we talk through it. But at a broad level, IHL is a subset of international law that's focused on limiting the destructive effects of armed conflicts. So it's a way to put some guardrails on the chaotic, destructive act that is warfare for humanitarian purposes. And what I mean by that is that IHL effectively is a compromise. IHL, it's important to realize and carry with you that it is not a body of law that operates as a block or a light switch to try to outlaw or make illegal all war or all effects of war. Quite frankly, if that was IHL's goal, it as a body of law wouldn't have survived the 19th century. Or even before that. So instead, you have this practically oriented body of law. And by that, I mean a body of law that recognizes at its core that there's going to be a certain amount of death, destruction, and injury that is inherent to war. It's inherent because in any conflict, there is a certain level of, as you see on the left, military necessity. You have to do certain things in a conflict in order to achieve your aims, to win the conflict, etc. However, for far too long in our history, that's the only consideration that existed. What do I need to do to win the war? I'll do anything. And civilians, civilian property, all of those are sort of footnotes and a means to an end. IHL attempts to insert itself as a fulcrum and balance on the other side, on that right side of the scale there, the interest of humanity, the interest of those who are no longer in the fight for reason of injury, surrender, etc., for civilians or civilian property, folks that are innocently just in harm's way because a conflict is happening in their area. And understand that the balance is never perfect. The existence of that fulcrum doesn't mean that IHL as a body of law gets it perfect. And we'll loop back to this sentiment toward the end of today's presentation. But it's critically important that that fulcrum remain, that a body of law exists to represent humanity's interest, to prioritize reduction of suffering in balance with military necessity. So we could go through an entire semester course, which would quite honestly be a dream course for me and maybe a snooze fest for many, on the origins of IHL or the rules of law. You could go back into the days of chivalry of knights and whatnot, but we're going to fast forward into the 19th century at a starting point of what I like to consider sort of modern IHL, quote unquote, as much as sort of the 1850s can be modern day. Uh, at the time, so I highlight the Battle of Solferino because it was a very seminal point in history. You don't need to know European history or anything like that to understand the importance of this war. Just understand that at the time, this was the largest land battle in all of Europe. This was a big deal, even if it's faded a bit in the memory of humanity collectively. By the noontime, the day of this battle, there were tens of thousands of folks who were littering the field of battle, injured or dead. And in the middle of all this, or in the immediate aftermath of the battle, this Swiss businessman, Henri Dunant, pictured there, finds his way to the outskirts of Solferino. He's there for his own purposes to try to execute a business deal. He's trying to get with the French commander, Napoleon, a descendant of Napoleon Bonaparte, and he comes upon the tremendous suffering that still exists on this battlefield. At that point in time, understand there are no medevacs, there are no battlefield medics. Battlefield medicine is at its complete infancy at this point in history. And so at that time, if you fell in battle, you either died or you hoped that if you survived, your side won so that you wouldn't be killed or ignored as the opposing side swept through what remained of the battlefield. Dunant stepped into this awful chaos and worked for several days, several sleepless days with civilians in the town to help render aid to those that had fallen injured in the battle. He walked away from that profoundly affected and set about a course that would ultimately lead to the First Geneva Convention just a few years later, as well as the creation of the Red Cross, Red Crescent International Movement. An ocean away in 1862, just a few years later, the Civil War in the United States is in its infancy. There at the Battle of Cedar Mountain in Northern Virginia, you had a young former patent clerk named Clara Barton who experienced her first taste of the battlefield there at Cedar Mountain. And she had many of the same experiences accompanying Union forces throughout the Civil War, witnessing firsthand the unchecked destructive effects of warfare and the suffering that followed it, no matter where it went. And so shortly after, this part didn't have to do with Clara Barton, but in 1863, the U.S. actually took a really extraordinary action. And President Lincoln signed into effect what's known as General Order 100, or it's better known as the Lieber Code. This was the first sort of trailblazing, modernized form of IHL. Understand that this general order, the Lieber Code, concerned Union forces only. This was not an international treaty. However, this started to this sort of seminal point represents a crossroads in time where a major government chose to take action to further limit the effects of warfare. At the time, many countries, to include the United States, had their own internal rules for how to conduct warfare. In fact, the U.S. had what's known as the 1807 Articles of War. These had sort of an infancy of what we might consider modern day IHL. But the Lieber Code really amped it up. It recognized that the U.S. was fighting an insurgent force that represented a very different challenge compared to the legalities of fighting another nation like Britain or France. And so you see this introduction of core concepts that remain prevalent today, such as military necessity in the use of force, a ban on torture, some refinement to prisoner of war status. Do Confederates who are not in uniform, spies, do they get POW status? This was really a trailblazing effort. And considering the circumstances, the lifeblood of the United States, the very existence of the country is very much in question in 1863. And yet, when faced with the decision to follow unchecked warfare in pursuit of sort of survival of the nation, or balance our war effort with a humanitarian bend to it, President Lincoln and the Union forces chose the latter, and that speaks volumes. I mentioned the first Geneva Convention. That came in 1864. This really provided the basic framework for protecting the sick and wounded on the battlefield. That was the focus of the first Geneva Convention. It ties back to Dunant's profound experience there in Solferino. It addresses those who are wounded in battle. It mandates that they must be humanely treated. You can't further injure them or execute them. You have an obligation to collect and care for those wounded. These were really revolutionary ideas at the time that substantially advanced the business of caring for those that were no longer in the fight, and ignoring, in a sense, the fact that they were previously fighting before they had been injured, recognizing that they still were humans and still needed assistance. Following at the end of that convention in 1864, only 12 nations signed on to this. So this is really a microcosm compared to the Geneva Conventions of 1949, which we'll touch on. But you had Britain, who signed on later in 1865, and then of note with the American Red Cross, Clara Barton threw her sort of reputational weight and the weight of our brand new organization just a couple decades later behind the effort to get the U.S. to sign on to this first Geneva Convention in the 1870s. You fast forward, some more wars happen, and you have another sort of high watermark in IHL, which is the Hague Conventions of 1899 and 1907. Understand that these aren't just two conventions. Baked within both of these, you have multiple conventions addressing various sort of more specific subject matter. But in 1899, you had nations come together and address some really sort of modern sounding or modern seeming concepts of warfare in an attempt to sort of humanize it more. So in particular, the ban of using poisonous gas munitions on the battlefield, the restriction against bombardment of undefended towns or habitations, no killing of surrendering soldiers. So Hague comes along, and a lot has happened in the progress of fighting, as it were, since 1864, and it attempts to gap fill using lessons learned from those conflicts in the intervening decades since GC1. 1907 comes along, and Teddy Roosevelt, still then president at the time, pushes for a new convention. The 1907 convention is largely focused on naval warfare concepts. It goes to expand the 1899 convention. And it's worth noting that these two conventions, they're still technically good law. They're sort of ancient in many ways and have been refined in terms of national practice and whatnot. But the core concepts live on from more than a century later. World War I breaks out in 1914, and this unleashes armed conflict that is unlike anything that the world has ever seen. Up to this point, conflicts are largely over, a battle is thought of in the sense of being fought over a day, maybe a handful of days. It's extraordinary if a battle lasts more than a few weeks at this point. And we're talking tens of thousands of soldiers. The total casualty numbers in the U.S. Civil War for service members total in a few hundred thousand, a significant number, but short of a million in just one battle. So the Battle of the Somme, I'll pick out in 1916. So a big British offensive. Just in that battle alone, on the first day, the British Army, ignoring all other forces, they had 20,000 soldiers killed on the first day of that battle. By the end of the battle, in November of that year, so it starts in July 1. By November, when the battle wraps up and this offensive is halted, keep in mind that this offensive claims just a handful of miles of territory, very small slice of geography. More than 1 to 1.2 million casualties are piled up on both sides. So World War One is unlike anything that the world has ever seen in terms of the scale of destruction and death. And you see IHL front and center. In fact, the Hague Conventions that we just mentioned, those are in controversy, right? You have this epic sort of globe-spanning war going on, and many people question the validity or the need for the concepts written on paper by diplomats at some foreign country and whatnot. The practicalities of war start to bleed in. And from the very outset of the war, as Germany invades at least one neutral state in Belgium, they become infamous for their acts of cruelty against Belgian civilians there. And so right away, you start to see that war and how it's conducted, the population's reaction to the war, sort of popular opinion, begin to shift and galvanize because of core concepts in IHL, treatment of civilians in particular. You go on in that war and you have the use of poison gas on both sides, many bombardments that severely impact civilian situations, millions of prisoners of war on both sides, the use of unrestricted submarine warfare. So German subs targeting civilian shipping, merchant shipping at will. It's an IHL issue in late 1917 that brings the United States into World War I. So again and again, you see these IHL-centric issues playing a key role. And World War I, like so many conflicts, shows us that oftentimes IHL is reactive. We have a conflict. Gaps are thrown open into the light in the law, and the world gets together after the fact to try to mend and bridge those gaps. And so in the aftermath of that war, you have some significant gaps in the law, gaps in Hague, gaps in the Geneva Convention that are unearthed, and you have multiple efforts that are made to try to close these gaps. Two notable ones that I'll just highlight here. You have a new Geneva Convention in 1929, specifically related to prisoners of war, and then you have a large-scale effort to further eliminate the use of poison gases on the battlefield. You fast forward to World War II, and again, in that 6-year span, I don't need to tell you the horrors that the world saw that advanced that destruction that we had seen just a few decades earlier. And so, in the ashes of World War II, on the heels of firebombing campaigns, the use of nuclear weapons, widespread carpet bombing across Europe. The list goes on to include especially the Holocaust. You had the world come together and give birth to the 4 Geneva Conventions, which just celebrated their 75th anniversary last year. So these GCs superseded what came before it. The first 2 Geneva Conventions concern land and naval warfare. The 3rd Geneva Conventions is solely dedicated to prisoners of war. And then you had a new 4th Geneva Convention related to the protection of civilians. These are one of the only universally ratified sets of international treaties on Earth. Every country is a high contracting party to these 4 Geneva Conventions. That's part of the longevity and legitimacy of those conventions. A few decades later, as proxy wars start to spring up all over the globe and warfare again evolves, you have 2 additional protocols that are brought into being in 1977. Additional Protocol 1, which has a number of provisions concerning international armed conflicts. Additional Protocol 2, which concerns what they call conflicts of a non-international character, which we'll touch on. So understand that these additional protocols and the third additional protocol that followed in the early 2000s were not universally ratified. There are countries that maintain reservations, that haven't signed on to all of it, but that's the track record of the Geneva Conventions. Understand that behind the Geneva Conventions, that's not all that IHL is built upon. To understand IHL, just walk away knowing that there are two main buckets in which IHL falls into. Your first is treaty law. We've covered a lot of those seminal treaties here in the last few minutes. It doesn't begin to scratch the surface on the number of ancillary treaties concerning things like use of particular weapons, so incendiary weapons, poisonous weapons, nuclear proliferation, et cetera, et cetera. The list goes on. But those international treaties are sort of our baseline understanding for IHL. You also have this unique aspect of IHL called customary law or customary international law, CIL. This is the idea that over time, the repeated practice, the repeated recognition of certain actions or inactions, so things that you don't do, are widely enough and recognized for long enough that they become customary. So even if it's not written in a treaty signed by nations and whatnot, this commonality, this practice over the course of time has solidified that particular practice as one that nations recognize they must follow and that other nations must follow. So you have this sort of undergird of that international treaty law with this customary base, which carries the force of law as well. This will become important when we come back around to the withdrawal of treaties at the end of the presentation. I want to very, very quickly orient you to the sort of trigger points for IHL, because not all armed conflicts are classified or created equal. Understand that it very much matters what type of armed conflict you are in. IHL is operable during times of armed conflict. Think about that. It's not necessarily the declaration of war. The last time a war was officially declared was Russia declaring war on Japan in 1945, shortly before World War II ended. Things work differently nowadays, and in fact work a lot differently then. But you have two main types of armed conflicts: international armed conflicts. So these are your classical country versus country types of conflicts. So think Russia and Ukraine currently. And when it comes to an international armed conflict, these trigger the entire body of IHL. So Common Article 2 to the Geneva Conventions and the full application of all four Geneva Conventions, and where applicable, there are any additional protocols. So those international conflicts, that's sort of the classical notion of warfare, this World War II idea where countries go against countries, and that's sort of the world experience. Well, additional protocol 2 recognized that war isn't always like that. It's not always the case that countries will fight other countries. You have to have a gradient to recognize that internal conflicts happen all the time. A government could be fighting a non-state armed group within the country. Multiple non-state armed groups could be fighting each other. That's just the reality. That was a gap that the international community recognized in the law. And so non-international armed conflicts occupy their own space, and they actually trigger a much, much narrower base of IHL. So rather than triggering the full scope of IHL, you trigger this narrow base, including Common Article 3 to the Geneva Conventions, Additional Protocol 2, and then where applicable, domestic laws. Understand that fundamental protections, so things like protection to civilians against targeted killing, bans on torture, the protection to human dignity, all those things still remain. It's not as if the gloves are off in non-international armed conflicts, but the scope of protections, as it were, is just much narrower in this field. Gianna, I will be quiet and intently listen to you take on the intersection with immigration law.
Thank you so much, Thomas. So next we'll delve deeper into asylum and refugee law. And this area of law is distinct from international humanitarian law, though of course they're both part of international law. And international refugee law grew out of international human rights law. And over time, it's kind of grown into its own distinct area of international law. And of course, with many parts of international law, there is overlap between international humanitarian law and asylum and refugee law. For example, armed conflicts can create refugee movements and the forced displacement of people. However, as we'll see later on today, not every person displaced by war or by armed conflict necessarily meets the definition of a refugee and is therefore able to obtain asylum under current US law, which requires a more individualized inquiry into why the person is being persecuted. But let's take a step back and discuss the origins of international refugee law. This takes us back to the aftermath of World War II, which Thomas has covered a bit. But the principles of international human rights law came out of the atrocities faced after this war and the Holocaust. And after the war ended, the United Nations was created, and the international community vowed to never again allow these atrocities to take place. So world leaders met and drafted a document called the Universal Declaration of Human Rights, which was intended to complement the UN's charter. And the Universal Declaration of Human Rights was officially adopted in 1948 in Paris by the United Nations General Assembly. The UDHR contains a comprehensive framework of rights that countries are encouraged to protect, and it sets the global standard for human dignity, freedom, and justice. Important for our purposes today, Article 14.1 of the Universal Declaration of Human Rights guarantees the right to seek asylum. It states, everyone has the right to seek and to enjoy in other countries asylum from persecution. Also relevant for our purposes today is Article 5, which prohibits torture. It states that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. So even though there had been some protections and recognition for refugees prior to the creation of the UN, the protections were limited and issued on a more ad hoc basis, and they were more tied to a person's country of origin. There wasn't a very organized system. After World War I, for example, countries established a set of international agreements to provide travel documents to people displaced by the war, but there wasn't a system like you see today. So just a few years after the drafting of the UDHL, we have the creation of one of the two key international law instruments that underlies international refugee law. So that is the 1951 Refugee Convention. And this is usually referred to as just the convention. And the convention combined with the 1967 Protocol on the Status of Refugees, which is usually called the Protocol. These are the two key documents that form the basis for international refugee law. They define the term refugee and outline the rights of refugees and the international standards for their protections. Next slide, please. Okay, so what is a refugee? The convention defines a refugee as someone who is unable or unwilling to return to their country of nationality owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership in a particular social group, or political opinion. You'll see the full definition there on your screen. And we'll get into this definition a little bit more later. Next slide, please. Okay. Another key part of the convention is the principle of non-refoulement, which states that no state can expel or return, refouler in French, and I'm not a French speaker, so apologies if that is not pronounced correctly, but essentially it means return a refugee to a territory where their life or freedom would be threatened. So this combined with the definition of refugee are the integral components of refugee law and the standards. Another important part of the convention is its obligation that parties generally not punish asylum seekers for entering their country without authorization. And this is because punishing asylum seekers would deter them from seeking asylum in the first place, thereby undermining the non-refoulement obligation. So the 1951 Refugee Convention legally recognized for the first time refugees based on their experience of displacement, rather than the previous system, as we discussed, that had focused more on country of origin. But the convention was originally limited only to people who were fleeing persecution in Europe since it came out of World War II. But luckily, the 1967 Protocol on the Status of Refugees removed these limitations. Only 26 countries participated in the original convention, but 145 countries have since ratified it, which means that they've stated their intention to comply with the convention's principles. And even countries that have not officially signed on are still influenced by the norms contained in the convention. They may want to engage in diplomacy with countries that are parties. And we spoke a little bit about norms in Thomas's section as well. But the principle of non-refoulement applies to all migrants. This is also important at all times, even in countries that are not signatories. And this is fortified by many other international human rights agreements. But we will discuss all of this and what it means later as we get into enforceability. Next, I'm going to talk a little bit about domestic US law on asylum and refugees, and how we've incorporated the international standards into our law. So over a decade after the 1967 protocol, and during an increase in the number of refugees caused by the Vietnam War, Congress passed the Refugee Act of 1980, and this amended the Immigration and Nationality Act, the INA. Congressional reports from the time that the act was passed show that it was meant to adopt the United Nations definition of a refugee and its rules on withholding of deportation. So the act created a uniform and comprehensive policy to proactively address refugee admissions in several ways. As mentioned, it incorporated the convention's definitions of a refugee into US law. It also provided the first statutory basis for obtaining asylum for individuals who are fleeing persecution who arrived in the United States. So it created the asylum system that we have today. And it increased the number of refugees that could be admitted annually and created the Office of Refugee Resettlement, the government agency that oversees the resettlement programs. And under the act, the president, in consultation with Congress, sets the annual number of refugee admissions. Importantly, the Refugee Act made it mandatory rather than discretionary for the Attorney General to withhold deportation of a non-citizen if the Attorney General determined that the person's life or freedom would be threatened in such country on account of their race, religion, nationality, or membership in a particular social group or their political opinion. And as you see, this matches the definition of a refugee contained in the convention. And this is what's the protection known as withholding of removal under US law. So we'll get into all of this a little bit more, but I'll note that this is called withholding of removal and not asylum. So we'll discuss the distinction there later on during the enforceability section. But this is just a bit of an overview on international refugee law and the US asylum system. And I'll pass it now back to Thomas to talk about enforceability. Oh, you're muted, Thomas.
Thank you. It always happens once. Let's see here. Okay, so enforcement is the number one question that I get after somebody asks, what is IHL? And you answer that one. They want to know how, okay, so you've got a body of law, and I understand it as a baseline, based on my experience with US law, say, but how does it get enforced? That doesn't, you have a lot of cynicism that creeps in when it comes to enforcement questions. To understand enforcement of IHL, understand that there are three main areas which are sort of centered on when it comes to this topic. War crimes, so those are grave breaches of the Geneva Conventions. Crimes against humanity, so targeted killings of civilians. It sort of stands on its own, separate and apart from war crimes. And then the act of a targeted elimination of a population in genocide. These are your three main areas that are concerned with enforcement and provide our foundational sort of piece going forward. Understand that a war crime can mean a lot of different things. So you could, just like in US law, where you have maybe a spectrum that is as wide as the country is of offenses, ranging from maybe a petty theft of a peppermint from a gas station to capital murder. The same holds true for IHL. You could have something like a petty theft of a low value item. That's technically a war crime. I personally prosecuted a lower level offense along these lines concerning larceny during my time on active duty. An officer who was smuggling stolen weapons out of Afghanistan to just resell to other gun buyers. And then obviously you have it scale all the way up to more egregious crimes. When we talk about the actual like active enforcement, so criminal prosecution, that sort of thing, you are going to see a narrower definition of war crime that is concerned with those grave breaches of IHL. That doesn't mean that everything or that IHL isn't concerned with some of its rules. But just like any other area of the law, enforcement runs head on into practical considerations such as time, expense, personnel power that's involved in investigating and pursuing these actions, and also just differing layers and mechanisms, which we'll get into as well. A criminal trial isn't the only way in which to pursue accountability for violation. Crimes against humanity, I mentioned as well. This and genocide are two of your other two long tent poles here. And whenever I talk enforcement, folks' brain understandably and immediately jumps to the idea of criminal accountability. Understand that it is critical that your idea of what is justice in a particular situation isn't necessarily going to be shared by every person under the sun. In fact, you see repeatedly throughout history consideration of those who have violated the laws of war treated in differing manners. And that's not because of a sense of injustice, but it's because practical considerations, cultural considerations, religious considerations, political considerations all bake in to the calculus to include what mechanisms are available at the time. Following the Civil War, your post-Civil War, U.S. Civil War, sort of criminal justice for Confederate officers, Confederate soldiers look very different. Not every Confederate who put on the uniform and raised the rifle against U.S. forces was tried in court. In fact, the vast overwhelming majority went back to their normal lives. You fast forward to World War I, as I mentioned, very, very few prosecutions came out of that war despite widespread atrocities. Things evolved further in World War II with the Nuremberg and Tokyo trials, and that's been the sort of case as we go forward. There is not a cookie cutter answer to what is enforcement, what is accountability, because it's going to differ on so many factors. I'll drop criminal accountability, as it were, into two main buckets: domestic means and international means, and we'll cover each briefly in turn. So domestic means it's exactly what it sounds like. A nation or a group internally is handling the pursuit of justice, the pursuit of accountability for an IHL violation within its own mechanisms. So I'll use the United States as an example. Both the U.S. criminal justice system and the military justice system, extended from the Uniform Code of Military Justice, so the criminal code that applies to the military. These are two major mechanisms used for domestic enforcement of IHL. If you were to crack the United States Code right now, you would find several of the sort of gravest provisions of the Geneva Conventions contained, codified within the U.S. Code. So you, as a U.S. citizen, can theoretically break federal law because portions of the Geneva Convention have been adopted and rolled into our criminal code. You don't see domestic prosecutions here in the U.S. just for, not for any single reason, but you don't see it happen often. But you do see the U.S. Department of Justice go after some of these crimes. A prime example are the Blackwater contractors. If you remember back in the early days of the Iraq War, you had several civilian contractors that were tried for murdering Iraqi civilians. That was an exercise of domestic means for IHL violations. Similarly, the military, and not just the US military, but militaries across the world have their own internal justice mechanisms in which to pursue IHL violations. The US military has its own criminal code, and a US court martial in our military system is akin to a federal trial. It's just that the players in it are all uniform typically. You have a military judge, a military jury, military prosecution and defense counsel, etc. So you have these domestic means, and I chose this picture on the top left because it's very sort of relevant to modern times. That individual picture, that young man, is a 19-year-old Russian soldier by the name of Igor Shishmarin, who is the first Russian soldier prosecuted in Ukrainian courts for an alleged war crime, murder of a Ukrainian civilian in the early days of the invasion there. So you've seen repeated trials that have happened in that conflict, and this is a very viable means. And in fact, when it comes to accountability, the preferred method, as the international community considers it, is for a country or an entity to handle things in the way that they see fit. So if a country is capable and willing to address these crimes or these allegations through its own means, that is the preferred method. The international means that exist understand that these are effectively a last resort. It is not preferred to bring in an international body of any type to a situation in which a country can handle its own business. And in fact, you don't see that happen. So you have, and I'm very oversimplifying things for the purposes of our limited time here together, but two main areas here that with obvious gradients underneath it. You have ad hoc tribunals. So these would be justice proceedings, criminal justice proceedings for war crimes that are stood up. Ad hoc doesn't mean that we just throw it together like in a back room that's filled with smoke and deal with this. Ad hoc tribunals would be things like the Nuremberg trials, convened just to address atrocities within World War II, the Tokyo trials, more modern tribunals in the former Yugoslavia, in Rwanda, Kosovo, etc. These are sort of freestanding international bodies that are set up in modern years through the United Nations. They are empowered with enforcement capabilities. They are empowered with to levy punitive punishments, so jail time, etc. And you have seen those with varying degrees of success throughout history during the 20th century. I suspect we are not done with ad hoc tribunals. Still, there are multiple ones going right now for past conflicts. With international means, understand that we think about our own system in the U.S. as being a slow justice system in some regards. Understand that international means of criminal accountability, there is often a long fuse between conflict or even the end of conflict and accountability. For something like the Kosovo chambers, which are still open today, that conflict was in the late 1990s, early 2000s, and yet we are still working through the accountability piece. You also have the International Criminal Court at The Hague. So this body was set up by the Rome Statute. It is not universally ratified. So the U.S. of note has not ratified the Rome Statute, even though we were instrumental in helping craft it and bring it into being. The U.S. has had a very sort of fraught up and down relationship with the ICC, but the ICC has jurisdiction to investigate and prosecute those three bucket areas: war crimes, crimes against humanity, and genocide where appropriate. There are jurisdictional questions that complicate every single action of the ICC. For instance, the ICC doesn't have jurisdiction at baseline in a conflict that involves parties who are not signatories to the Rome Statute. There, again, are exceptions to that. But you see the ICC has been in the news quite frequently recently in both Ukraine and in the Israel and Gaza conflict. And we'll touch a little bit more on them when we get to sort of future consequences and things to expect. Gianna, back to you.
Thanks, Thomas. So we're going to briefly discuss now the enforceability of international refugee law. And as we discussed, the United States is a party to the 1967 Refugee Protocol, and that incorporates Articles 2 through 34 of the Refugee Convention. And so we previously discussed the convention's prohibition on refoulement, and that's found under Article 33 and states that a member state may not expel or return a refugee to a place where their life or freedom would be threatened because of a protected ground. However, so we've signed on to this treaty, but whether a treaty is legally binding under US law depends on whether it's considered self-executing or non-self-executing. So a self-executing treaty is considered to have the force of US domestic law without Congress needing to pass implementing legislation. If a treaty is considered non-self-executing, on the other hand, it is not directly enforceable in the US courts. So US federal courts have held that the Refugee Protocol is not self-executing for domestic law purposes. Because of that, the Refugee Protocol in itself creates no judicially enforceable rights or duties beyond those granted by the implementing legislation, which we discussed. So Congress implemented the Refugee Convention's non-refoulement obligations under the Refugee Act of 1980, but it was implemented under the INA's withholding of removal section, making it a mandatory form of protection, unlike asylum, which under the INA is considered a discretionary form of relief. So even if you qualify, a judge or USCIS can still deny your asylum application based on discretion. That's not the case with withholding of removal, but withholding of removal is a lesser protection and does not provide the same benefits as asylum. So the Supreme Court has discussed this distinction, noting that while withholding of removal corresponds with Article 33 of the Convention, asylum, on the other hand, is based in Article 34 of the Convention, which only requires a contracting state to facilitate the assimilation and naturalization of refugees. So the Supreme Court therefore interpreted Article 34 as a discretionary provision that does not require the implementing authority to actually grant asylum to everyone who is eligible. So that's the status of international refugee law and how it can be enforced in US courts. However, there's a lot to be said for the effects of the convention and how it's still influential, of course, even if it's not judicially enforceable. So the Supreme Court has long held that international law is part of our law. And aside from directly enforcing the Refugee Convention, federal courts are generally obligated to interpret federal statutes in a way that avoids violating international law. So that's still the case. And this is commonly known to lawyers as the Charming Betsy canon after a Supreme Court case called Murray v. the Schooner Charming Betsy. And in that case, Chief Justice John Marshall declared that a statute ought never to be construed to violate the law of nations if any other possible construction remains. But I will note that Congress is allowed to pass legislation that's contrary to international law if the stated purpose of the act is to supersede that international law or if the two cannot be fairly reconciled. But I think, there's a lot to be said for shaming in the international law sphere, and that's something that international law in general relies heavily on to shame or pressure countries into complying, and this can be especially impactful when dealing with a less powerful country. In particular, it's difficult to put to use when the issue involves a country as powerful as the United States, especially because the United States has historically been a leader in resettling refugees, for example. So it's difficult for other countries to try to shame us when they're not necessarily upholding their own commitments to international and refugee law. So I think it's a challenge. The convention and the protocol provide these protections, but states do often ignore them or unfortunately impose barriers on accepting refugees or allowing individuals to seek asylum that are contrary to the principles contained in these international treaties. So on that note, I will pass it back to Thomas.
This time I will unmute myself. You touch the hot stove a million times and you're bound to learn at some point. So within IHL, understandably, this is a complex web of treaties and customary law, domestic laws. Uh, when it comes to the business of individual treaties themselves within IHL, I'll use the US as an example, given the audience here. And the business of withdrawing from treaties is actually, it's a constitutional question, I guess, in a sense. Article 2, Section 2 gives the president the authority with the advice and consent of the Senate to enter into treaties. It's silent as to the withdrawal of treaties. So the founders were forward thinking, but maybe not that forward thinking. They should have been, because it didn't take long for us to withdraw from a treaty in 1798. You have that happen. We're on the eve of war with France, and Congress passes legislation. John Adams signs it, withdrawing from 4 major treaties with France. They just did that. There's nothing in the constitutional text that says that that's how it has to happen. And the few hundred years since then has seen all manner of sort of withdrawal and nullification of treaties happen from the United States in terms of like the mechanisms. So you will see from time to time in U.S. history, Congress pass legislation, the president signs it, and that's the way that we withdraw or terminate a treaty. You've also seen the president take unilateral action at different points in time. Occasionally, you've had Congress come back and after the fact pass legislation to sort of shore up or I guess cement the president's prior withdrawal from a treaty. But usually what's involved is some form of notice to the other nations, the other parties to the treaty. It's treated as a shared power, even though this sort of legal ball has been tossed around over the decades. It's treated as a shared power between the legislature and the executive branches. And I don't think that we're going to get any help from Congress or excuse me, the Supreme Court in the anytime in the future on this issue to try to clarify it, because they took this issue up in 1978, or at least in a way they did. President Carter had just withdrawn the United States from a defense treaty with Taiwan. In the case of Goldwater versus Carter, Congress sued to try to stop that unilateral action. The Supreme Court dismissed the case or dealt with the case without reaching the ultimate question of what should the constitutional answer be. And effectively, the commentary is that this is a political question. And so repeatedly since then, the court has batted away this sort of issue, treating it as a political question that's not right for the courts to decide. And so when it comes to the business of, are we going to withdraw? How do we withdraw? I think a lot depends on who's in the office and who controls the levers of Congress. In what we're about to step into in a single party control of both houses and the executive branch, I think things move more fluidly, assuming that there's agreement and one side's action isn't completely controversial to the other sort of body. Layered on top of this, I won't go down this rabbit hole, but there's something called the Vienna Law of Treaties, which is exactly as exciting as it sounds. Anybody that took the Vienna Law of Treaties, I guess in law school, you can come sit with me at the lunch table. We'll stick together, lonely as it were. But when it comes to withdrawal or nullification of treaties, Vienna says either follow the terms of the treaty. What does the treaty say about how you're supposed to withdraw? Or in a nutshell, you provide 12 months notice of your intent to withdraw or nullify the treaty. That's it in a nutshell. The Geneva Conventions in particular, I'll just pull those because we've talked about them a lot. They have text within each of them, within each of the 4, that concerns withdrawal or nullification of the treaty. It involves notice to the Swiss Federal Council. And 1 year after that notice, that high contracting party, so that's just their term for a signatory to the treaty, they are out of the treaty. That withdrawal doesn't affect the obligations of any other high contracting party. And there's a caveat that if the country that's trying to withdraw is actively involved in an armed conflict, that withdrawal isn't effective until peace is concluded, as it were. It doesn't fully define what peace is concluded means, but basically the conflict has to be over before you get to withdraw and not do the things that Geneva requires you to do. I will note that withdrawing from an IHL treaty doesn't erase customary international law. So understand that those repeated practices over the years to try to sweep those away would take an equal amount of practice or different mechanisms entirely. The president, Congress can't just sit there and declare that we're no longer going to abide by a custom. It wouldn't work that way. I don't know that that's been tested, at least in my memory recently, but very different mechanism from treaty withdrawal. Gianna.
Thanks. So I will briefly discuss how the United States has dialed back its commitments to the convention and the protocol. We saw numerous attacks on asylum during the first Trump administration, which appeared to be clear violations of non-refoulement and punishment of asylum seekers in particular. Many of these were issued as asylum bans in the form of regulations, typically interim final rules, which go into effect almost immediately and do not allow an opportunity for the public to provide comments. But under the Biden administration, we've seen a bit of a continuation of these policies as well. We essentially have a combination of 2 Trump administration asylum bans in place right now at the border, and they were issued by the Biden administration. They're called the Circumvention of Lawful Pathways Rule and the Secure the Border Rule. So the Biden administration issued the Circumvention of Lawful Pathways Regulation, the CLP, in May of 2023. And so the rule combines the Trump era ban on asylum for individuals who entered without inspection. This was known as the EWI ban, and the transit ban, which banned from asylum people who had crossed through another country en route to the United States without applying for asylum in that country. So essentially anyone who passed through Mexico, which is anyone at the southern border who appeared on foot, would be subject to this restriction. So that's in place now through the CLP, which creates a rebuttable presumption of ineligibility for asylum based on how the person entered the United States and whether they applied for asylum while in transit. And if the rule applies, the person is no longer eligible for asylum and can only apply for withholding of removal or protection under the Convention Against Torture, which are lesser protections, and they do not allow for derivatives or a path to US citizenship. The second ban that's currently in place was instituted in June of last year, June 2024. This is the Secure the Border, or the STB rule. So it largely expands on the CLP rule, but adds additional restrictions and hurdles to asylum access at the border. It predicates access to asylum on border encounter numbers. So the policy has a trigger, which means it goes into effect when there's a 7 consecutive day average of 2,500 migrant encounters or more between ports of entry. And it stays into effect until 14 calendar days after a 28 consecutive day average of less than 1,500 encounters between ports of entry. So this may sound like a lot of math, but this bar will be in effect most of the time since February 2021, daily migrant encounters have exceeded those numbers every single day. So the STB sets a higher legal standard for withholding of removal, and also prevents people from being eligible for asylum while it's in effect. It also imposes a shout test, what immigration practitioners are calling a shout test, which means that people must actively manifest their fear of return by telling border officials that they'd like to seek asylum or are afraid to return, instead of officials proactively asking them. And as we know, that is very difficult. There's often language barriers, or people are experiencing trauma from just having crossed the border. So both of these rules are creating serious access issues to asylum at the border right now. And they're both being litigated, but they're both still in effect. We did see similar bans vacated under the Trump administration by the federal courts. So I think the difficult thing, as we saw, is that the courts have determined that the protocol is not self-executing. There are still clever ways to bring international law into US federal litigation of these types of cases, but the way that most of these bans have been previously struck down is by arguing that they're contrary to the INA, which has incorporated certain aspects of the Refugee Convention, as we discussed. For example, the INA states that a person is eligible for asylum regardless of their manner of entry, and this aligns with the protocol's prohibition on punishment of refugees as well. Other bans have been struck down based on violations of the Administrative Procedure Act, which is a law governing how administrative agencies must make their decisions. So courts have found that the agencies have sometimes not followed the proper procedures when enacting these new policies, or that their decisions are considered arbitrary and capricious under the law. So if the courts allow these bans to remain in place, it's likely the Trump administration will keep them in place, since they are restricting access to asylum so severely, but he'll likely modify them to remove some of the currently existing exceptions, so make it even more difficult to access protection. But I'll briefly speak about some additional restrictions we'll probably see. I know we're out of time. We will likely see the renewal of asylum cooperative agreements. Under the Trump administration, we did sign these agreements with Guatemala, Honduras, and El Salvador, allowing the US to send individuals who are seeking asylum to those countries to seek asylum in a third country, as opposed to here in the United States. These agreements were suspended under the Biden administration, but would likely be reinstated by Trump. And the issue with the agreements is that the INA requires that a country have a full and fair asylum system in place before it could be considered a safe third country. So we do have a safe third country agreement with Canada. There's been a determination that they have a full and fair asylum system. That wasn't the case for these other 3 agreements that were signed. We're also likely to see the renewal of MPP, or the Migrant Protection Protocols, or the Remain in Mexico program, which the Supreme Court did say could go forward. But the Biden administration has not been putting it into effect. We're likely to see lowered admissions of refugees. Under the Trump administration, the number of refugees resettled in the US plummeted to just around 11,000. And the Biden administration last year resettled over 100,000 refugees. So unfortunately, we're likely to see that number plummet again. Changes to asylum law. I won't get into this too much, but Project 2025 does include a section on doing away with one of the protected grounds for asylum that's included in the INA, and that's the particular social group ground. This ground is already one that's extremely difficult. There's a lot of case law surrounding what it means to be part of a particular social group. Much of it conflicts. I think courts themselves have trouble deciphering this ground, but this would require changing the law. So I think it's unlikely that would happen, even though we're in a Republican-controlled Congress now. But I do think the Trump administration will use previous tactics, such as using attorney general decisions to change the meaning of this requirement, this protected ground. So that was a quick overview. There, we of course expect many other things, but that we can't cover everything in 1 hour, unfortunately. So I think we unfortunately don't have time for questions. But thank you so much to Thomas. And if any of our participants have questions, please feel free to email us. Our contact information is included here on the slides. And we will be emailing out a copy of the presentation. And yes, feel free to email us we at GYH will be having more of these election-focused webinars in the future.
And I want to thank GYH and Gianna, you for your partnership and for helping put this great event together. It's been a pleasure putting this together. I hope we can work together on something similar in the future. If you want to learn more about Red Cross IHL programs or just IHL in general, how you can get involved in our volunteer-led IHL dissemination efforts, you can go to redcross.org/IHL or follow that QR code to our page. You can also check out our repository of IHL content spanning everything from academic lectures to panel presentations and many things in between at our YouTube channel. It's at American Red Cross IHL, or you can follow that QR code. Thanks again to everyone for coming. Thanks for agreeing to have me on as part of this great presentation, Gianna.
Thank you so much, Thomas. It was a pleasure. I look forward to working with you again. Thanks to all of our viewers.